this presentation is now about current EU regulatory aspects of the Safe by Design approach in the field of nanotechnologies. So it's really meant to be complementary to the presentation we just had on the Asian perspective. And more precisely, the content of this presentation is divided in three parts. First of all, we will cover the current EU regulatory framework of nanotechnologies, which is both a complex regulatory environment, as we will see, and it faces for many years the legal question about the definition of nanotechnologies and more precisely nanomaterials. Then the second part will be devoted to the fact that there is currently no legal definition of safe by design in EU law, but we will see that it is not 100% correct to say that there is nothing in EU law currently. And finally, we will cover the current EU regulatory framework of product safety and to see to which extent the current regulatory framework already addresses some of the concerns that are at the core of the safe by design or safer by design approach. And we will, of course, end up with a conclusion about the regulatory framework. The first statement to make for this presentation is that law is, first of all, a question of wording. In the title of our project, we have the question about safety by design of nanomaterials. That is to say, with the word safety, first of all, what is safety about? And safety for whom? These questions are very important for lawyers, and you will see why. By design, that raises the questions, what is design, who designs, and when? When is there any design? And of nanomaterials, then we will come back later to the question, what are nanomaterials from a legal perspective under EU law? Words are important because legal regimes, as you might be familiar with it, they have different scopes which limit their applicability. A territorial scope, when we speak about the European Union, that covers the member states of the European Union. And if some treaties of the European Union extend to a certain point legal rules applicable in the European Union, that will define the territorial scope of the legal rule. We have a scope that is called in Latin, well, in law we like Latin words, scope ratione personae. That is to say, who is the relevant person? Who has to comply with the legal obligations? And that's an important question when it comes to safe by design. Then we have also the question about what does the legal regime apply, the scope ratione materiae. So that's also very important to understand what a legal regime exactly covers and what it doesn't cover. And I can tell you as a lawyer in private practice, that is at the core of these legal disputes, especially between authorities and mostly companies, about what the law requires private individuals or companies to do, and what is the perspective from regulatory authorities. On the next slide, we will start our journey in the current EU regulatory framework of nanotechnologies. And on the next slide, we will first of all start this journey by identifying the complex regulatory environment of what we can call nanotechnology law in the European Union. Here, that is a kind of very personal summary, but to show you that lawyers tend to be educated in law faculties with an increasing tendency towards specialization. And of course, very often, we don't have a full picture from a legal perspective of what an innovation cycle is about. And so, of course, this is to remind that when we speak about the legal track of any innovation, that involves different legal fields in which we need to look into in order to be, first of all, compliant, and secondly, knowledgeable about the legal aspects that apply or could apply to the said innovation. On the next slide, this is where you will find out that the regulatory framework of nanotechnologies is pretty complex in the European Union. In the left-hand column, you see that there is already legislation in the European Union with specific provisions dealing with, first of all, food law. That's the first legal area where we have had in the European Union legal provisions dealing with nanotechnologies, first of all, and then later on, more precisely, nanomaterials. The other area where we have had pieces of legislation covering nanotech aspects is basically the field of cosmetics, and then we have the biocidal products regulation, and we have also some national registers, but I will come back to this later on. In the right-hand column, you see that, of course, you can have pieces of legislation that specifically, in their own wording, address nanotech legal issues, but that doesn't mean that the rest of the legislation doesn't apply to any activities involving more or less nanotechnologies. So on the right-hand side, you see that the legal environment is pretty complex. And when you have new technologies, such as nanotechnologies, you always ask yourself whether the current legislation already applies or not to the technologies. It's not because the technology is new that the legislation adopted before the adoption or market entrance of the technology does not apply. And that's probably one of the great virtues of good legal texts, is that they are very robust and they can survive to the evolution of technologies, because they define core principles which apply irrespective of technological evolutions. We have also a role, very important role devoted, of course, to standardization, and of course, regulatory guidance needs to be taken into account. On the next slide, you will see that one of the turning points during these last years from a policy perspective, but when we speak about policy, we speak about law also, was the Berlin Declaration in 2018. And in this Berlin Declaration, and you see that much more precisely on the next slide, you have some of the excerpts taken from the Berlin Declaration deal with different challenges of the nanotech policy. And one of these is the European Commission recommendation of 18 October 2011 on the definition of nanomaterial, which is currently under review. Horizon Europe is coming. There was a political agreement at the end of last year, and so we expect this to be turned into a regulation anytime soon. And so, of course, the Berlin Declaration was also important because it was a declaration made after the development of EU Nano Observatory, and of course, now with a permanent mandate given to the European Chemicals Agency. And so this is just the state, I would say, of the art concerning the policy, the trend. But then on the next slide, you will see that you may think in the word European Union, you may think that union means coordinations, convergence of legislation. And in this field, nanotechnology, quite surprisingly, member states have used and relied on provisions from the European legislation to take national initiatives, which is quite, I would say, uncommon. That the tendency in EU law, in any legal field covered by EU law, is to have convergence initiatives taken at European level instead of the member states level. But here with nanotechnologies, we have seen the first member state was France. We have seen so far 4 EU member states, and then another one, Norway, being in the European Economic Area, having adopted national nanotech registers, nanomaterials registers. And basically, the member states have relied on an exemption provided in the REACH regulation, and which allows member states to further adopt national measures. And you see on the next slide that national registers have been adopted in 4 EU member states and in 1 European Economic Area member state. The national registers are quite interesting because this adds further complexity to the correct understanding of the regulatory environment of nanotechnologies and nanomaterials in the European Union. Think about, there was a question about exporters, that is to say importers from the European perspective. If you have an exporting company from Asia, the question will be with which legal provisions does this company have to comply when it places products on the market in the European Union, because we have European legislation and then we have 4+1 member states having their own national provisions. So that adds complexity to the legal environment, and that further requires also some kind of discipline, because unlike, I would say, very large states around the world, in the European Union, at European level, working language, there are 3 working, I would say practically 3 main working languages, and English is still the most used one in the European institutions. But of course, when you come to national provisions, they are drafted in the national language. So it means that, for instance, when you work on the Danish register, fortunately, there was a translation provided in English, which made it more accessible. But again, that adds complexity, because in terms of access to information, then you need to be familiar, sometimes even with the local language. On the next slide, you will see that the core question, and that is further exacerbated by the existence of national registers, because they contain their own definition of the term nanomaterials. A big challenge we have seen during the last 10 years is really the legal definition of nanotechnologies and nanomaterials. On this slide, you see that it started in the area of food law. Not surprising, because in the food sector, you have legal provisions that are adopted to provide greater protection to consumers. And of course, it's not surprising that this is the area in EU law where we have seen the first legal provisions dealing with nanotechnologies and then nanomaterials. But in the first regulation, that was the one on food additives, the term nanotechnologies that was used in a provision was not defined. So very interestingly, at the time when you adopt a legal text and you refer to nanotechnologies, you do not define it. Well, it means that from a legal perspective, it really opened the floodgates to further interpretation, even before courts. But then in 2009, there was another regulation, a very specific one, where there was the first definition in a legally binding text adopted by European institutions, and which defines then nanotechnologies there. And so, of course, the definition was quite small when you see what came afterwards. In 2011, there was another regulation, and there the definition was referring to substances in the nano form. We will come back to this word later on. But then you see in the cosmetics regulation, there was another definition given. So you see that within a very short time frame of 3 years, basically, even less than 3 years, we have 4 different regulations that have a totally different definition, which could be fine, because of course the purpose, and that was raised by an attendee in the question session of the previous presentation. We can have different definitions because the purpose of regulation is very different. But it is very interesting to see that what was the status in 2011, that is to say, we had different definitions across the European legislation. But on the next slide, you see that, and that was in fact 7 days after the European Commission adopted its recommendation for a definition of the term nanomaterial, the European Parliament and the Council adopted regulation on the food information to consumers. You may ask yourself why after the recommendation of the Commission, this legal text adopted a totally different definition? Well, the reason is very simple, is that the legislative process at European Union takes so much time that by the time it reached the adoption stage, of course, it was too late to integrate even the recommendation of the European Commission. And here we see that this regulation has been amended in 2015 by the Novel Food Regulation with exactly the same definition as in the Novel Food Regulation, which takes the definition you see now on this slide. But the decision was taken at that time that it's much more likely if we amend the definition in the Novel Food Regulation, automatically we will amend the definition of the term engineered nanomaterial in the Food Information to Consumer Regulation. So it's interesting that the European legislator started to build links between pieces of legislation in order to develop maybe a comprehensive set of legal rules. But on the next slide, you will see that the European recommendation of 18 October 2011 was quite different. I'm not going into much detail about it, but you see here that you have basically a definition that includes, of course, a reference to the number size distribution, to the size range. You have different criteria that are used in this definition. And you see on the next slide that the recommendation of the European Commission made in 2011 was further implemented in 3 pieces of legislation. That is to say, the one on biocides, the one on food intended for infants and young children, and also in the medical device regulation. But the end result is that basically you have a set of legislation today where the legal definition is not the same for cosmetics, it's not the same in food legislation, or most of food legislation, and is not the same when it comes to biocides or medical devices. On the next slide, you see that we may come to the question, why should we have a single legal definition? Of course, the issue is that the real issue is that legal definitions do not necessarily match the purpose of science-based definitions. And so, of course, to summarize scientific issues in a few words could be really challenging. So that's the first food for thought. But then we have also, from a political perspective, some issues to address, because in 2014, the European Commission tried to amend the Food Information to Consumer Regulation by implementing with an executive order, if you want, the recommendation made in October 2011. And then we had the European Parliament filing a resolution which basically forbade the European Commission from doing this. And in fact, very interestingly, I remember that was published on the 19th of December in the official journal of the European Union, and the next day it was withdrawn. So very interestingly, we see that there was a political game behind, and very interestingly is that in European institutions, the position of European institutions is not the same whether we should have a single legal definition or not. The European Commission has promoted a single definition with a recommendation, and the European Parliament doesn't back that perspective. We see, of course, and that was already mentioned, that the Novel Foods Regulation now contains the same definition as the Information to Consumer Regulation. On the next slide, we see that in 2018, the concept of nanofoam was introduced into REACH. I'm not going to further discuss that because that could be the purpose of a very separate presentation or even workshop. But again, we see that now the word used in REACH, and that was one of the main challenges, was whether REACH should be amended or not, is the word nanoform, not nanomaterial, it's nanoform. So of course, lawyers, we pay attention to words, and again, we have another definition which is used in a piece of European legislation. But when we come to the second part of this presentation, on the next slide, we will find out that we have a complex regulatory environment with nanotechnologies, but we have so far no legal definition of what safe by design in EU law means. You see on the next slide that there is currently no legal definition of what safe by design means, but we cannot quickly come to the conclusion there is nothing to say about it. Because interestingly, in a totally different area, we have a communication from the European Commission on future networks and the internet from 2008, and where it says that that it is necessary to take steps now to make the internet of the future safe by design. So words are not neutral, and we lawyers, we pay attention to what is basically, what is the occurrence we have in the European legislation. Communications are not legally binding, but they serve as further guidance when it comes to policy making. We have another occurrence in the Commission decision of 7 March 2013 on safer requirements for certain seeds for children. And we see in the annex to this Commission decision that basically products need to be safe by design as far as possible. So it's very interesting to see that the language of safe by design is used in totally different areas than nanotechnology. And so this is where we can start thinking, well, maybe we have to look a bit further. We need to have a global perspective. And that will be why today we will have a presentation of privacy by design. It's precisely because the wording is interesting and it's also important. The legal foundations of the safe by design concept are already there, and that will be covered in another presentation this afternoon. But in the field of environmental policy, we have a provision of the Treaty on the Functioning of the European Union. So that is to say, one of the two treaties that defines the way the European Union works, and we have a provision that protects and enshrines in the most fundamental law of the European Union the precautionary principle. And the precautionary principle is a key element when it comes to the legal foundations of the safe by design concept. Precautionary principle has been further interpreted, discussed, but this is not the only legal foundation, in my humble opinion, of the safe by design concept under EU law. We have a provision also in the Treaty on the Functioning of the European Union concerning the high level of human health protection that should be ensured by the institutions and member states. And we have also the provision also on a high level of consumer protection. So among not only the objectives, but also the policy basis of the European Union, we have the protection of the environment, the protection of human health, the protection of consumers. So safe by design has legal foundations. The question is how and whether it should even be further defined in legislation which will be adopted on the basis of the treaties that define the European Union. And in the third part of this presentation, we see that the current EU regulatory framework of product safety provides already some interesting answers to our question whether we should further regulate or not. First of all, with product safety legal rules regarding consumers. The first one is the Product Liability Directive. I'm not going to cover it extensively, but just to mention that the Product Liability Directive, it's one of the oldest pieces of EU legislation still applicable. It is under review, and we expect that anytime it will be replaced by another directive. But you see, we are more than 35 years later, and I can tell you that there are very few pieces of legislation in European law where a legal text survives more than 20 years. And that is the case here. And so basically, we have the Product Liability Directive that was adopted way before many technologies were extensively discussed. I do not say they did not exist, not at all, but the legal challenges caused by the technologies were not even discussed, and nanotechnology was not a matter of safety concern in 1985. It was not part of the public debate. And so we see that the Product Liability Directive has been adopted at a time that basically technological evolution was not as fast as today. On the next slide, you see that the Product Liability Directive established a system of non-fault liability. And so, of course, there is a question about the burden of proof. And the objective of the directive was really to find a compromise between the interests of victims and producers, in the sense that there should be a fair distribution of damage risk. And that is a very key element, liability. Because when we speak about safe by design, we think about what happens if it is unsafe by design. And then from a legal perspective, we think about liability, torts claims before courts. And so, of course, we see that there are differences, of course, that can be used. And among the differences, we have compliance with mandatory regulations, which puts some responsibility on the shoulders of lawmakers, because when they adopt regulations and say we should have a technology matching these objectives, if it is unsafe because the lawmaker has decided so, then of course that will be a reliable and effective defense. And of course, and this is where again the debate is very widely open, is the state of scientific and technological knowledge. It's also a possible defense to say I'm not liable for the damage caused by the product, because the state of scientific and technical knowledge at the time was not such as to enable the existence of the defect to be discovered. And this is where we see there is plenty of discussion room for question about access to data, access to knowledge, but that will come back later today in the workshop. We have also the General Product Safety Directive from 2001, which is also a legal text that should be taken into account. And so, of course, we see that we have a legal framework that already imposes obligations, for instance, on producers. And on the next slide, you see that when it comes to consumer protection, it's even about unfair commercial practices. That is to say, a producer cannot claim a product to be safe or to have been, for instance, checked or approved by an authority or certification body when it's not the case. So, of course, a consumer could have several legal grounds to file a claim and say that the practice was deceptive. And that's also applying to comparative advertising. A producer claiming that the products are safer than those of competing producers. So in the field of consumer protection, there are several pieces of legislation that should be taken into the characterization from a legal perspective of safe by design. But then, and that's the second part of the second section of this third part of the presentation, we have product safety regarding workers. And on the next slide, you see that it starts with the 89 Framework Directive on Workers' Health and Safety. That basically applies. And that applies, and the directive has to be adopted to technological progress. So the language, and that's interesting, the legal language at the time was short and anticipated technological evolution up to a point that it was better to have general principles and basically allow further interpretation and adapt the interpretation over the time, instead of having a too much detailed legal text. That is to say, that is how it was drafted in the field of occupational safety. On the next slide, you see that the Chemical Agents Directive also has the same type of language. And so, of course, Chemical Agents Directive is also a piece of legislation that should be taken into account if we discuss about safe or safer by design approaches, especially for working. Professor Andrew Nelson mentioned that working in laboratories 40 years ago was not that safe. and not as safe as today. So this is a way to show you that legislation, at least more than 20 years ago, as you can see, was drafted in a way that technological evolution was anticipated, and there was still room for further interpretation, evolutive interpretation of legal text. But we are now reaching the end of the presentation with the next slide. Thank you. And there are a few elements I would like just to point out to open the discussion and have questions from the audience. With the example of the various definitions of the term nanomaterial, we see that too much precise wording can go sometimes against the general purpose of legislation. Because if you define a term so narrowly, it's so easy to escape to the applicability of legislation. And that's precisely sometimes at the core of some debates and challenges before the European courts, the Court of Justice, for instance, is precisely because the wording, and there are stakeholders which want to avoid the applicability of legislation, and they challenge the wording. And they say that they do not fall under a piece of legislation precisely because the wording is ambiguous or is too complex. From a legal perspective, the safe by design approach could also, and we have seen that, already fall under general mandatory obligations of safety. The question is again, how can we further interpret these provisions in the light of the scientific knowledge that has been accumulated over the last years? And the real challenge might not be whether we should regulate more, but how we could better regulate. That is to say, find the right legal instruments to achieve the objective, the policy objective: protection of environment, protection of human health, protection of consumers. We see that safety and liability issues are intrinsically linked. If something is unsafe, automatically the question is whether there should be liability for the unsafe product and harm caused to workers, to consumers, or to the environment. But with the rise of legal technologies, and especially the increased use of artificial intelligence, and that is very much promoted sometimes, we can ask ourselves whether in the future, and it's already the case for some of them, regulatory authorities and even judges will interpret legal text with the help of legal technologies. And this is where you will see the link between the legal language and the code. That is to say, all legal words which are written, taught in a certain language, or they can be computerized. And that will be discussed later this afternoon. So these are a few elements I wanted to share with the audience, and I will be happy to take questions as from now. Thank you very much.